Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Donald Ross, welcome to 2019.
Happy New Year, Jim.
So for the viewers that haven't seen the show, just give them a little description about yourself, background.
I'm an attorney in Naples. Been a member of the bar since 1981, have my master's in tax, the attorney for Downing Fry Realty for 20-odd years, one of the owners at Downing Fry. Have my own title company, Ross Title and Escrow, around the corner of 6th Avenue North and 41. 7 closers. Do quite a few closings. My own law firm. Again, been there for, gosh, over 20 years, a long time.
Right. Well, Don, today we're going to go back and look at 2018, and we're going to see about what are the most common mistakes either buyers made, sellers, or even agents, okay?
Sure.
So the first one we're going to talk about is Irma. There's been a lot of problems, even 2 years down or a year and a half down from Irma on claims. So maybe you want to touch base on that.
Well, as I was saying before the show, I've gotten 5 phone calls in the last 24 hours. People who've closed, people who are in the process of closing, who want the seller to file a claim for a new roof. Or feel they're entitled to a new roof. Essentially, you know, they're not entitled to a new roof, and they're trying to get the sellers to make this claim under their insurance policy, which allows for replacement value. So you could have a 15-year-old roof, which I had earlier this morning,
right,
and they get a brand new roof, versus the sales contract, which says limited roof life is not a defective item. So you could have a 19-year-old roof under the sales contract, and as long as it's not leaking or is still structurally sound, the seller is compliant under the sales contract. But under his insurance policy, he may or may not be entitled to a replacement roof if there's some minimal damage, which still leaves it structurally sound. So that is still up there. I get it all the time. I get people who are upset that they're getting a special assessment now for something relating to Irma, and it's been more than a year later, and really that they're not entitled to any relief, but it's still out there.
So that we were talking before the show, that's in one of my questions here, assessments, okay? So
right,
if the assessment is done prior to the contract or during the contract, the seller would pay?
Yes, so we have, it's paragraph 6 under the Naples Board of Realtors contract, and what they do is any assessments that are voted on, certain as the amount, the lien or the party doing the lien and so forth, you know, if it's before the effective date of the contract, the seller pays it. If it's after the effective date and before closing, the buyer pays up to 1% of the purchase price. So if they vote on something after the contract's signed and delivered to both sides, and let's say it's a $300,000 property and the assessment is less than 1% of $300,000, which would be $3,000.
Right.
Let's say the assessment's $1,000. It's the buyer's responsibility. In that example, if the assessment were $4,000, the buyer would have an opportunity to cancel the contract if the seller were unwilling to pay the extra $1,000, the difference between $3,000 and $4,000.
Right.
So, but I'm getting things way past closing.
That's right.
Where tiles may have shifted. One this morning, again, it's a 15-year-old asphalt shingle roof. They normally last 20 years, and they're missing a couple of shingles. And the inspector's saying the trees that adjoin the home may have damaged some of the shingles.
Right. Yeah, these inspectors, right?
Yes.
So
some of them just make issues.
Exactly,
I mean, to be very blunt about it.
We
They have no clue what's in the contract, and they get the buyers overly concerned.
So if I want to get off the assessments, but one more question. Okay?
Sure, sure.
If somebody, seller, knows there might be an assessment coming in the next 6 months or something, should they disclose that to the buyer or not?
Legally, they don't have to if it's not going to affect the fair market value of the property. Assessments are a funny thing. Some of them, like my 15-year-old roof, if you are able to get a brand new roof and it costs you just the deductible, that's an upgrade. That's actually an improvement. It's like winning the lottery. You're doing very, very well, but people don't look at it that way. Legally, the seller does not have to disclose a future special assessment if it will not affect the fair market value of the property. Now, that's legally. Just because legally that's all you have to do doesn't mean you shouldn't do it.
Right.
I recommend disclosing. I always recommend disclosing. I get more clients who just feel like they've been had when the seller doesn't tell them. And if it's an expensive transaction, $1 million transaction or more, the buyer just feels like they've been played. And they're more apt to file a lawsuit. They're more apt to file an ethics complaint against the realtor if the realtor didn't tell them about it. So it's not good business, in my experience over 30 years of doing this, of not being totally transparent. It's bad.
How about wire fraud?
Wire fraud is the #1 issue out there. It's not going away. It's getting worse. You know, being the attorney again for Downing Fry, I see more issues relating to wire fraud than the typical closing title company or law firm. #1 source would be the seller or the buyer not calling to confirm wire instructions. #2 might be, and this is almost always the case, the person who's hacked into is either the realtor, the seller, or the buyer. You know, they got a Gmail, they have an AOL account, they haven't changed their password in 20 years. You know, and the fraudsters will hack into their email, watch what's going on, and at some point impersonate one of the parties and give a doctored up set of wire instructions, which I've seen happen.
Right.
And money ended up, you know, out of the country.
Yeah, I hear
Gone.
it all the time. I mean, not all the time, but we've heard a lot of cases of that.
Yeah, realtors shouldn't be handling wire instructions.
No,
period. End of story. Never, ever, ever.
Yep.
And nobody should. And I had a conversation with a realtor this morning who was also the seller. She's moving to France. She's British and she's moving to France because, believe it or not, she says it's cheaper to live there than to live here. But she wanted the money wired to New York. And we require original wire instructions signed by her and notarized. And I cautioned her. I said, in many cases, it's safer for the seller just to get a check, even if it takes 2 or 3 days to clear. It's safer. So,
how about escrow money? Trying to get your escrow money back if the contract is, you know, terminated or violated or whatever.
Well, we have. I had one this morning. I had to leave word for the seller who was looking. There was $2,000 escrowed for certain permit issues that were not resolved prior to closing. And it really comes down to how the escrow agreement is phrased, because the sales contract does not talk about what language should be in the escrow agreement, except that the seller would be liable for any amounts above and beyond the escrow amount. That's in there. And you're supposed to escrow twice the estimated cost to complete the permit process or complete the repair, whatever it might be. Some of these things, it's last minute. You can't get an estimate. Permits, you never know what it's going to cost to complete it. So, you know, in this case, the escrow agreement was phrased using the words indirectly or directly related to obtaining the permit closure, something along those lines. But indirectly and directly was definitely in there. And we have an invoice for $950. There's $2,000 in escrow. And it involved visits to the permit department and all that directly and indirectly related to that. And the seller saying, I want the whole $2,000. And the money is held by the buyer's attorney, another attorney, not myself. And he's just not responding to our emails. So I have to tell the client, you're going to have to sue. Now, getting your money back under, say, condo review or, you know, an as-is due diligence period, I'm not seeing, if it's within one of those two areas, I'm not seeing much of a problem with that. I know NABOR is revising their forms for the direction to release deposits, and you know, with the notice to the buyer, notice to the seller, and they both have additional language, and they're not released quite yet. It should be soon. but there's additional language that notifies the buyer and the seller, whoever it might be, that the escrow agent, in other words, the title company or the law firm, may require something signed by both parties before they release the monies. I mean, if it's at all putting the escrow agent at risk, they're not going to release it unless both parties sign.
Okay, well, Don, before we continue on here, we're going to take a little short break, and we're going to be back in 1 minute.
Right.
We're going to hear a little bit about the York Real Estate Group.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Don, let's talk about walkthroughs. You know, going at the end, we're ready to close. Agents walking through for a buyer.
I think I was telling you before the show, that is a huge liability for any realtor. The realtor can be sued for negligence. The realtor is considered an expert. There is a recent case out of Miami-Dade where the realtor just showed a rental unit to some people. There were some smudges of paint on the floor. People moved in and they discovered that it was much worse than they thought. The realtor volunteered to try to help rectify these issues. That they found the pipes were leaking, there was mold in the unit, the people had children, the kids had to go on medication. They ended up canceling their 2-year lease and suing the owner and the realtor for negligence. They also sued the realtor for fraud, but that was dismissed. The appellate court said, yes, the realtor can be sued for negligence, even if you're not getting paid for what you're doing. You're volunteering.
To do it.
You're doing the walkthrough. I mean, you're licensed to sell real estate. You are not licensed to do home inspections. Most realtors aren't.
Right,
Maybe
exactly.
you are.
No, I'm not.
You have a builder's license, but unless you're licensed to do whatever it is, you know, practice law like I do, or deal with insurance issues, or deal with lender issues, let that person do the work. If you, the realtor, step in and do a walkthrough, when really it should be the inspection company doing the walkthrough. It doesn't cost much to have them do the walkthrough. Might be $100 or $200. If you volunteer to do that and you miss something like this Miami-Dade case, you could be liable. In that case, the owner paid over $82,000 and was remanded to the trial court to see if that was enough.
Well, that was a big mistake, I guess, right? 82,000.
And it looked like nothing.
Right,
it looked like there's just some smudges of paint and on the floor.
Oh my God! So filling out contracts incorrectly, how does that affect buyers, sellers, agents? Because we see it, we see it all the time. I guess there's what over 2,000 new agents and.
Well,
you know,
I think there's closer to 3,000.
3,000 or whatever.
You know, I'm a big fan of filling in every blank because at a minimum it makes you read it, and you have to point out to your client, hey, here's paragraph 6, and oh, this deals with special assessments, here's paragraph 4, it deals with financing. Quite frequently we have too much information on the Homeowners Association summary disclosure. This morning I had people who were buying a lot for $300,000 and building a $2 million house on it. And on the lot purchase, it had the purchase price as $300,000, $30,000 deposit, cash to close, $905,000. And I look at that and I go, what?
Yeah.
What? So I have them.
Sure
I have them and say, what is this? I don't understand what it means. A common one is not filling out the financing contingency clause, which really is two parts. It's in NABOR, it's paragraph 4, which gives you your interest rate, your term, and then in paragraph 1, it gives the amount of the mortgage. So you really need to do both paragraphs. And frequently, they leave out paragraph 1, so it's subject to somebody getting a 4.5% mortgage, 30 years, but we don't know how much. It's uncertain. Or I'll have, under paragraph 1, they have a line for financing, how much financing you're getting. Then you get to paragraph 4, and they'll check off cash. And I'll say, well, what is it?
What is it?
Is there a loan or not?
Right.
And often I'll get the selling agent tell me, well, they're going to get an equity line on their home up north. He says, well, but this has nothing to do with this real estate here. You can draft it a certain way. I can review it after you do it because you don't want the agent practicing law, but this is the wrong way to do it. So then you get people, or the realtors, who are filling out seller's disclosures for their clients. You want all that in the seller's handwriting.
That's right.
Because their memories may not be the same as yours after something comes up after closing. So I would say those are probably the most common errors. Not filling it out completely, leaving out certain addenda, like the HOA addenda, or putting too much information on the HOA addenda, being overly helpful. Their heart's in a good place. They want to answer all their clients' questions, but they're not licensed to be the attorney. They're not licensed to do walkthroughs. They're not licensed to do anything other than sell real estate.
How about inspection issues?
Oh, well, we have, whether you use the statewide contract, FAR/BAR, or the Naples contract has a form, buyer's election, seller's response. And with buyer's election now, they have an itemized list of specifically what the buyer wants fixed. A lot of agents don't use that itemized form. They might use the summary from the inspection report, so that's an issue. And just this morning I had an agent who had a list of like 40-odd items, and most of them are relatively minor, asking me what's defective under the contract. And there was one item where the buyer was asking the seller to fix the damp molding behind the toilet next to the shower downstairs. Now, dampness in and of itself is not a defective item under either contract. If there's dampness caused by something that's broken, like a leaky roof, a seal broken on a toilet, grout in the shower, a pipe behind the wall, it's the buyer's responsibility to identify what the defective item is. Is there a leaky pipe? Is there a leaky seal with the toilet? Is there a hole in the grout in the shower? And then the seller can respond specifically and say, yes, I will fix the grout. Yes, I will fix the seal of the donut that the toilet sits on. And it'd be fine. But I warn this realtor, tell the buyer specifically what you're going to do about the dampness on the molding behind the toilet. You're either going to replace the molding or you're going to fix grout. Be specific. Don't just say, I'm going to fix it, because we don't know what it is. It could be a pipe. It could be the toilet. It could be the shower. It could be a cracked shower pan. We don't know.
And finally here is buyer going in a new community and not being represented by an agent. What are you seeing there? I mean, it's not costing them anything, right?
It's my mother and father-in-law showing up Monday, and this is one of their pet things to do. They love going around and God love them, waste realtors' time and go look at all the lovely property in Naples or Marco where they're staying. And I think that's just human nature. It's like me going to look at cars, or your son to go look at new golf courses. And so our clients will walk in there and they'll meet the friendly salesperson for whatever developer it happens to be. Say, oh, what a nice person, what a lovely, salesmen are nice for a living. That's what you're supposed to be doing. And they think they don't need help. They don't fully appreciate that person works for the developer. It's their job to get you to sign something.
Right.
They're not looking out for you. They're looking out for, you know, their
developer.
year-end bonus with their boss, the developer. So they don't check off Jim York as their realtor or whoever it might be.
On the registration form.
Or, and I looked at a
Right.
contract this morning for somebody. They used their particular title company. And I said, well, you're using them. I'll answer questions for free, but
Right.
you know, you made the choice. They just think this is the easiest. Let's go with the flow. And it's only later when they start to get treated a little
Differently.
than they thought they should be treated that they want to change.
Yeah, you always need those other eyes from an agent.
It costs you nothing.
It costs them nothing,
Nothing.
and it's just one-sided. Nothing against the developer or anything like
No.
that, but they're there to sell their product, and you need somebody
Well,
that
it's
right.
like walkthroughs. The more eyes you have looking at something, you're
Something.
more apt to pick something up. And if you pick out the person
Yep.
who has the eyes, they work for you.
Yep.
So it costs nothing, and why wouldn't you have your own realtor, really?
Well, Don, thanks for coming on the show. I look
Thanks for
forward to
asking me.
working with you
Appreciate it.
again in 2019 with the show here,
Good
and
luck this
also
year.
with your people in your office.
Thank you,
do a
Jim.
wonderful job.
Always
for
a
our
pleasure.
clients.
Thank you.
Thank you for tuning in today, and we'll see you next month. Thank you.